liens and foreclosures. So the way I've structured this, we'll talk about authority to assess. We'll talk about collection policies and what kind of things should go in those policies, liens, lawsuits. We'll spend a little bit of time on foreclosure. We'll also spend a little bit of time on bankruptcy, and throughout we'll give lots of tips and tricks. Now, one of the big caveats that I give at the beginning of all of these is some of you were in Oregon, some of you were in Washington. The statutes in both have what we call default provisions, but most of the time your governing documents prevail. So when I say certain things like, I'm trying to think of a good example. I usually, when I give examples, I'm referring to the statutory defaults. So if in your mind you're thinking, no, that's not what we do in our association, I know that. I understand that. And your governing documents, all of your governing documents are going to be different and unique. And it's a little bit of a process to figure out which of times the statute prevails over your governing documents and vice versa. Where there are significant differences between Oregon and Washington, we'll point those out. And so, probably within the next few months, we're probably going to start doing 2 of these a month, one for Oregon and one for Washington. We've been talking about that and discussing that, so that's something that might be forthcoming. Now, let me briefly walk you through a timeline of a standard collections sort of a file, as I would call it. And this timeline starts with once it gets turned over to our office for collections. In a little bit, we'll talk about what happens in the stages that occur prior to it coming to our office. But once it's turned over to our office, we generally will file a lien against the lot or the unit. We also send an initial 30-day demand letter. I won't spend hardly any time on this. In fact, I'll just mention it now. There are laws governing the collection of debt, which apply to debt collectors. We do a fair amount of debt collection on behalf of HOAs and condos. And so we are subject to what is referred to as the Federal Fair Debt Collections Practices Act. And that mandates that we send this initial 30-day letter. So we send that letter. If there's no response to that, we send a final 10-day demand letter. If there's no response to that, we generally will file a lawsuit against the owner. That's the more common remedy, is filing a lawsuit against the owner. We'll talk about foreclosures in just a little bit. Now, most of the time, after we file a lawsuit, in Oregon, the debtor has 30 days to respond, in Washington, 20 days. But if there's no response within the required time frame, we file and get what's called a default judgment. We win. We don't even have to go to trial because the debtor did not appear in the lawsuit. And then we move into what's called the collection of the judgment phase. And we have a lot of judgments. Whether you can collect on those judgments is sometimes an interesting question. If folks have jobs or a source of income, we have the legal right to garnish bank accounts, wages, vehicles, and we'll talk about collection methods at the very end. But this is sort of a general timeline, and this process can take anywhere from 4 to sometimes a year if it gets challenged. So if they do file a response and hire a lawyer, it will go to sometimes binding arbitration, otherwise just a regular trial. And that process can take a while. The wheels of justice grind very, very slowly. Now, Bruce, would you spend a moment and talk about what is an assessment? Is it fines? Is it regular dues? Is it special assessments? Is it attorney fees?
Yes. So assessments are any charge levied by an association against the lot or the unit. So it would include interest, late fees, regular assessments, special assessments, fines, and collection costs, at least under many of the statutes that we're talking about. I think that Washington Homeowners Association Act might not specifically allow collections cost, but oftentimes governing documents do it anyway. But generally speaking, assessments are any charge levied by the association against the owner.
Beautiful. Now, Bruce, don't go too far because I'm going to ask you to talk about fines in just a moment. But let's spend just a moment on the authority to assess. Generally speaking, the authority to assess must be in the CC&Rs or the declaration. Generally, the provisions governing assessments, sometimes they'll have a cap. It might say something like the total assessments for each lot or unit may not exceed X amount of dollars. Or if it does exceed it, it requires a vote of the owners. Sometimes it will also identify a right for the association to charge interest and state the interest amount. Sometimes, in addition to the interest, it also authorizes a late fee. So when an assessment does become delinquent, there can be a lot of, the bill adds up, especially if there are hefty late fees or interest. Bruce, am I correct in both jurisdictions that the authority to assess must be in the declaration or CC&Rs? I believe so, in both Washington and Oregon, and both types of communities.
I think if there's no authority to assess in the CC&Rs, then it's not a planned community. And so
Good point.
It doesn't come under the jurisdiction of the statutes. I mean, condominium, I've never seen a condominium that wouldn't have the authority to assess in the documents.
Yeah,
so,
good point.
But I think if there's no authority to assess in a set of CC&Rs for individually owned lots, it probably isn't governed by the statute. So then the statutory authority wouldn't apply also.
Good point.
Yeah, under the statute, it does. I think it's required that any obligation to pay assessments is included in the declaration. What's interesting, though, in Oregon, is an interesting question of law is if the CC&Rs have a cap on assessments, is that enforceable? Because there's a statutory provision that says that the board is obligated to assess all common expenses against the owners. So is that a conflict? And I don't know the answer to that.
That's a very academic question. Thank you, Bruce. Now, Bruce, don't go too far. Let's talk for a minute about fines, the requirements to levy a fine. And Bruce, I think you said earlier, fines, if properly levied, are considered an assessment, and therefore you can collect those just as you would any delinquent assessment. But talk for a moment just about the notice and opportunity requirements, please.
Sure. So fines, a prerequisite to levying a fine is that the owner be given notice and an opportunity to be heard. So it doesn't technically say an opportunity for a hearing, it says an opportunity to be heard. That's usually interpreted as a hearing before the board, but I know some associations that interpret that as, owners may be able to submit their objection to a fine in writing. I'm not sure there's case law on that. So there's those two prerequisites, is that you have to provide them notice, you have to provide them an opportunity to be heard prior to levying the fine. Also, the fines have to be based on a schedule of fines that was previously adopted and distributed to all owners. And the fines have to be reasonable. So there's a number of requirements before you can levy fines against a lot for violations of the governing documents.
Well said. Thank you. By the way, Michael O'Rourke, I just saw you. Good to see you.
Hey, good to see
How
you.
long have you been on
Thanks.
the board, by the way? We've known each other for quite some time.
2017.
I thought you were going to say
Yeah.
27 years, but 2017. So it's been a little while.
2017.
Well, good to see you.
Good to see you. Thanks.
Now, in terms of options, when an owner doesn't pay, we'll talk about sort of the steps leading up to before you go through the process of filing a lawsuit or a foreclosure. But generally, the two options are filing a lawsuit, and the law says that delinquent assessment is a personal obligation of the owner, even if they move. So if an owner is delinquent on their assessments and they, I don't know, for whatever reason, abandon the property or sell it, and it doesn't go through a title company, they're still personally obligated to pay that delinquent assessment. The other option, and one that generally isn't exercised as much, is foreclosure. And one of the takeaways tonight is that as associations, you have a fair amount of authority to take someone's property, which is a very serious thing, which is why we don't do it very often. A lot of the times it depends on the equity in the property, depends on the amount of the delinquency. So there's a lot of criteria that goes into that. We'll talk about foreclosure more in just a second. Let's talk about collections policies. We write a lot of collections policies for associations that we represent. And the first step is, when is the assessment considered delinquent? And different governing documents have different language. Sometimes it's delinquent the day after if it's not paid. Others will say the assessment is levied on, say, February 1st, and it's considered delinquent if not paid within 30 days. So one of the things we do is a careful review of the governing documents and make sure that whatever policies and procedure that the association is going to follow is in compliance with the governing documents. And that's the other important thing, is that you do have some sort of written policy governing collection of assessments that every owner has a copy of, every new purchaser gets a copy of, and it walks the owners through step by step. Here are the consequences if you don't timely pay your assessments. It needs to address the late fees and the amount of interest if your governing documents authorize that. The timing of demand letters. Now, some associations, especially if assessments are levied annually, it might be a couple of years worth of delinquencies before their policy document says this is when you turn it over to the association. Other communities where assessments are levied monthly, it depends, whatever the board says, or sometimes the governing documents specify. Some associations like to send 2, sometimes 3 courtesy reminders saying, hey, your assessment that was due on whatever date, you still haven't paid it, please pay it. Otherwise, we're going to have to go to the next step pursuant to our written policy. Now, here's a couple of screenshots. By the way, I despise legalese. And you won't hear many lawyers say that. I hate the use of whereas, anyway, this is a collections policy I found that I just didn't like, mainly because of the use of whereas in all capitals. Now, there's a reason I don't like legalese in most cases. And the reason for that is when it comes to community associations, for most folks that live in one, this is their most significant investment of their entire lives, their property. And to me, it's crazy that you are required to comply with governing documents or rules and regulations that aren't written in plain English that a normal person of average intelligence couldn't understand and interpret. I think that's nuts. My preference is to write it in as plain English as possible. So actually, I took kind of this and rewrote it in plain English, and I'll show you some more examples. But I like to walk the owners through the authority to assess, citing to the specific provisions of the governing documents. And even here, we put the reason it's vital to the economic stability of the association that every owner pay their share of the association's expenses. Now, here's a sample sort of first steps in plain English. Once an assessment's more than 90 days delinquent, the association will send a notice to the owner with the amount due. Okay. Once the assessment is 100 days delinquent, the association is going to turn it over to our office. We will then send an initial demand for payment and record a lien against the property. Now, one of the things we put in here is that anytime that it's been turned over to the attorney's office, we get to handle it from then on. And there's a reason for that. If we're litigating it, everything needs to go through our office. But then we put, if the assessment still isn't paid after our second demand letter, we're either going to file a lawsuit or initiate foreclosure. Once we obtain a judgment, we may do one or all of these things: garnish a bank account, wages, execute a writ. By the way, Emma is one of our collections paralegals, and she has recently become an expert in writs in Clark County. Oh. Emma just disappeared. Emma, did you turn your video off because you thought I was going to call on you?
No, I was frozen in a kind of unflattering
Oh,
picture.
understood. You're off the hook. I might call on you in just a moment.
Okay.
Okay. Now, other remedies. And this is going to depend primarily on the language in your governing documents. It could also depend on whether you're in Oregon or Washington and which type of community you're in. Some communities have the authority to turn off utilities to delinquent owners. And that usually gets folks' attention if the water is turned off or electric. Now, a lot of communities aren't set up that way. You can't just turn off power or any utility to an individual unit. So you can only do that if you've got the ability to turn off a utility for a specific unit. There's a large planned community that actually Bruce does most of their work in Central Oregon. And one of the big reasons that folks move there and live there is because there's a big golf course right smack in the middle and everyone loves it. And people play golf every day. Now, under their governing documents, they have language that says if an owner is delinquent in their assessments, we can turn off your fob that lets you into the golf course. And let me tell you, folks, it's effective when folks show up and their fob doesn't work to golf and they realize it's because they're delinquent. You know what they do? They go into the manager's office with their checkbook and they usually cut a check. But again, you've got to have that authority in your governing documents. Some governing documents also allow the board to suspend the right of the owner to vote, which I've never thought of that as much of a consequence. If an owner's not paying their assessments, my guess is they probably don't care too much about voting for directors or other things, but who knows, it could be effective. All right, now let's talk about personal judgment lawsuits. And this is sort of the last straw. The association has given the owner notice. It's now been turned over to the attorney, and the attorney or collections agency has given them notice, and still nothing. You file a lawsuit. And it's a pretty serious thing to sue someone, but sometimes that's the last resort and the only way that you can get folks to contribute. I mentioned that once the lawsuit's filed in Oregon, the delinquent owner has 30 days to file what's called an answer or a response. In Washington, 20 days. Here's where I'm going to call on you, Emma. How long generally in Washington and Oregon does a trial date get set once filed?
In Oregon, after the defendant answers, you would set it in about 4 to 6 months after the answer is filed. In Washington, it would be longer, I think, probably about a year after we filed the lawsuit, I believe.
Good answer. I agree with everything you just said. Now, as I mentioned, statistically, most folks, delinquent debtors, do not hire a lawyer and file a response, and then we secure what's called a default judgment. And then again, that's where the fun part starts, collecting that judgment. Now, Bruce, can I put you on the spot again?
Maybe.
What's the board's authority if, let's say, a lawsuit has been filed and the owner comes to the board or to our office and says, hey, I want to work out a deal. Will you reduce some of what's owed in assessments? Does the board have the authority to make compromises? Can they waive interest in order to get it resolved and get the owner back to a zero balance and pay in their monthly assessments?
Yeah, so long as they're acting in the best interest of the association.
I like that. Yeah. Now, one thing that we frequently do, if we come to some sort of agreement or compromise, is we request that the defaulting or delinquent owner sign what's called a confession of judgment. Bruce, explain a confession of judgment, please.
So it's a document that if it gets filed, it essentially turns into a judgment which skips the trial process. So when we work out a payment plan, we don't have any obligation to agree to a payment plan. So one of the conditions is that the owner essentially admit that they owe the money. And then if they default on the payment plan, we can now go back into court, file the confession of judgment, and we have the judgment without having to go through the trial process.
Yeah, and that gives us a little bit of extra security to make sure that that's the payment plan is complied with. All right, now I'm going to talk for a little bit about liens, because the moment an assessment becomes delinquent, it's very weird, but poof, there's also this automatic lien that arises. By the way, lien is from a Latin word that means to tie or to bind. And that's what a lien does, is it attaches itself to the property, not the person, but the property. Now, as far as foreclosure of liens, I'll talk about that in just a second, but I want to talk about the importance of liens. If there is a lien on the property and a delinquent owner attempts to sell it, presumably the buyer, unless they're paying all cash, is going to go through a title company. And one of the things the title company does is they review and examine the recorded documents to see if there's a recorded lien against the property. But what I just said a second ago, which is in a lot of circumstances, these liens arise automatically. And that is why anytime an owner goes to sell or to refinance, you or your management company is going to get a questionnaire from the title company asking questions. And one of the primary questions is, are there any outstanding or delinquent assessments? That's the title company's way of asking, is there one of these automatic liens on the property? And the title company will not issue a title policy unless that lien is satisfied. Emma, how often do we get payoff requests? It depends on what the economy is doing, but we get a payoff request frequently that says someone's trying to sell, how much is owed, ballpark, how often do we get them?
I would say once a week.
Once a week, yeah. And liens depend, and I'm not going to go into much detail because depending on which state you're in and what type of community, different liens last for different times. For those of you in Oregon, liens last for 6 years and then you can renew them. Washington is a little bit of a complicated analysis, so I'm not going to get into details about that. But a lien authorizes the association to foreclose on it. But what you don't want to do is get into a situation where you're foreclosing on a property that has no equity, because whoever purchases it at a sheriff's auction after foreclosure takes it subject to any existing mortgages. Now I'm going to spend about 30 seconds on what's called lien priority. The general law of liens is that whoever records first has higher priority. For those of you in Oregon, if you're a planned community, that lien by statute is always just below the first mortgage or deed of trust. In Oregon condominiums, if you send a statutory notice, you can actually jump ahead of that, which gives you a lot of authority. That's all I'm going to say on lien priority. But the takeaway from that is the law gives the associations a lot of legal tools to collect delinquent assessments. And the policy behind that is your livelihood and your ability to operate the association completely and entirely depends on your ability to collect assessments and owners willingly and voluntarily paying their fair share. Now, the foreclosure process, if it comes to a point where that's the best option, can also take a while. You may have heard of the term non-judicial foreclosure. That we don't have that for HOA or condo liens. It has to go through the judicial system to foreclose on these liens. And that's similar to a lawsuit. You file a lawsuit, again, they got 30 or 20 days to respond. There's a trial, and at the end of the day, a judge decides whether the foreclosure moves forward. Now, one thing we always do if we do a foreclosure is we get what's called a foreclosure guarantee, which is an insurance policy from the title company that says, here are all of the potential folks that have an interest in the property. And the reason we do that is because when we file a foreclosure lawsuit, we have to name each one of these interest holders as defendants in the lawsuit. If we don't, then we don't have any effect on their mortgage or their lien. So we have to name them as defendants. It looks something like this. This is a guarantee. This is a foreclosure guarantee. And dependent in Washington, they can be a little more expensive. In Oregon, these guarantees are a little cheaper. Emma, what's the ballpark cost for a foreclosure guarantee in both jurisdictions? Ballpark?
For like a regular residential property,
Yeah.
I think between 500 and 800.
Yeah, that sounds about right. Yeah, and that's a critical, we won't move forward with a foreclosure action unless we get one of these title policies, these guarantees. Now, the process, we do some rough math, we do some research, a little bit of due diligence to determine whether there's equity in the property. We get the foreclosure guarantee from the title company so we can determine the other lien holders. And then we file the foreclosure suit. Now, you may have heard of this term right of redemption. What this means is that if the association or the condo moves forward and successfully prevails on a foreclosure action, usually the delinquent owner has what's called a right of redemption. Sometimes 120, depending on where you're at, 120, 180 days, where if they can come up with the funds to cure the default, they can get the property back. They can redeem the property. And that's what's called a right of redemption. Questions so far? You all are a little quiet. Now, I get it. This isn't the most exciting of topics, but it's certainly one of the more important ones. Hopefully you're not falling asleep yet.
No.
Okay. I guess it's time for a joke. Grasshopper walks into a bar. Bartender says, "Hey, we got a cocktail named after you." The grasshopper says, "Interesting. You have a cocktail named Ned?"
What?
All right, that didn't go over well. Colleen, okay. Michael, you have a question. Fire away.
Okay, so I have a question. We had that there wasn't a lien in place, but there was a unit, a sale of a unit it was a private sale. The renter who had been living there for a long time bought it from the owner, and we didn't know about it until they emailed and said, "Hey, I'm the new owner. Where do I go to pay my dues?" And we're like, "What?"
Yeah.
So with our special assessment, especially,
The
are
lien
we
is still
running-
on the unit.
are we running a risk of us not knowing? I mean, so the title company, it would get disclosed at some point. Let's say
If the buyer goes through and gets title insurance, but sometimes all cash transaction, they might waive that and not even bother, which is a huge risk in my opinion. And the risk here is that they just bought a condo that has a lien on it.
and they may or may not know that.
That's true.
That's what I'm afraid of happening. Then they're going to be like, "Well, we're not paying this." Well,
Email me
it's
tomorrow.
unlikely.
Email me tomorrow, Michael, and I'll write them a letter to let them know.
I see. It's hypothetical though. but
Yeah, of course.
Yeah. Okay.
By the way, Michael, not to toot my own horn, but that letter I wrote to the garbage service, it worked, didn't it?
Yes, sir. I think the customer service rep, we finally found one that was sympathetic enough
Good.
that they made the end date. They pushed it up. So thank you.
Good. All right, Michael, great question.
There's another question, Kevin.
Yeah, I see. Okay. We have an owner who never pays their assessments on time and haven't paid for 2023. It was due January 31st. I've sent a couple reminders. Are we already at a point where we should turn it over to you? Should we send them one or more reminders saying we will send this to you? Yeah. So Roberta, I don't know if you have a collections policy in place. If you don't, we should put one together very quickly. And a lot of it depends on the amount of the annual assessment. I live in an HOA and our annual assessments are $70 a year. Everyone pays it. But would I be willing to take on and file a lawsuit against someone over $70? Probably not. It doesn't look good, even if we legally would have the right to do it. But Roberta, yeah, let's talk offline tomorrow, and we can get you set up with a collections policy. Yeah, one thing, and Roberta suggested, should we send a couple of reminders? Absolutely. And here's why I always recommend send reminders, knock on doors if you need to, because there have been a few circumstances over the years where a file has been turned over to us and we send our initial letter and we get a phone call the next day that says, oh my word, I'm sorry, I switched bank accounts and I forgot to update my new bank account for auto pay with the management company. In those circumstances where it was completely unintentional, I write off everything, close it out, they pay and they get up to speed. So there are sometimes circumstances like that, but it's ultimately up to the board. And sometimes it depends on, the amount of the assessments, whether or not it makes sense to send 2-3 letters before you turn it over to us or another collections agency. So a lot of it just depends on the specific community as to whether or not I, make a recommendation on the number of reminders and that sort of thing. Let me talk for a moment about bankruptcy. Now, a bankruptcy and a foreclosure together often mean the association is never, ever going to see those funds again. And that does sometimes happen. Now, bankruptcy is complicated, and I will be the first to admit that none of us are experts in bankruptcy. This is a very highly complicated area of the law. But we know enough when it comes to assessments. And a lot of it depends on what chapter the debtor files under. Chapter 7 generally is liquidation and you will completely lose out your right to collect assessments that accrued prior to filing of the bankruptcy petition. Contrast that with a chapter 13, which usually results in the creditors getting some amount of payment. It might be 10 cents on the dollar, it might be 1 cent on the dollar. But ultimately, a bankruptcy judge in conjunction with a bankruptcy trustee sorts that out and figures out how much the creditors should be paid based on what the individual who filed bankruptcy could potentially afford. Bruce, do you want to talk for a minute about what an automatic stay means?
Sure. Once the owner files bankruptcy, there is an automatic stay on any other litigation against that individual. So in the context of collection of assessments, if we're in the process of bringing a lawsuit, on the moment when that person files bankruptcy, all activity on that lawsuit has to stop until the bankruptcy is completed.
And then Bruce, you want to take the most recent question in the chat box?
If our owners paid dues once per year, can we assess late fees every month, or is it just one late fee? It's a good question. I think it's really at the board's discretion. You can adopt a resolution that authorizes late fees, but if it's an annual assessment, it would just be one late fee, right? You wouldn't continue to pile on monthly late fees, but you can add interest on monthly.
Yeah, and sometimes your governing documents will be very specific. Late fee, you can charge it annually. Sometimes interest is actually spelled out and specified in the governing documents as well. Now let's talk for a minute about settlement and payment plans. So if we have a collections file and it's been turned over to us and the owner contacts us and says, hey, we'd like to work something out. At the end of the day, that is always a decision that is left up to the board of directors. And as lawyers, we have an ethical obligation to convey all settlement offers, even ridiculous settlement offers. But our obligation is anytime we receive an offer, we have an obligation to convey that to you, and that's what we do. Usually it will follow with a recommendation, which is something like, yes, this seems reasonable and this makes sense. But at the end of the day, if the board doesn't like the recommendation, it's up to the board as to whether or not they accept a settlement. If there is a settlement reached, we prepare payment plans. We do a confession of judgment, which Bruce explained about earlier. And then life moves on. Payments continue, and assuming the payments continue, they'll reach a zero balance. We release the lien and life goes back to normal. Now, if we can't reach a settlement or a payment plan, in Oregon, most of the time, because the amount of the claim is less than 50,000, it goes to what's called court mandated arbitration. So it's no different than a trial, but instead of a judge, it's a lawyer in the community who acts as an arbitrator. You put on witnesses, evidence, documentary evidence, and then the arbitrator makes a decision. And again, this is specific to Oregon. If you don't like that decision, either party can request a trial de novo, meaning a brand new trial in circuit court. Now, Washington State, some of you have provisions in your governing documents that say any dispute must go through arbitration, but if not, it gets filed in Superior Court and works its way through the court system until we get a judgment of some sort. Sometimes that's a trial. And those are fun. Trials are fun. The legal system is interesting. Now, let's talk for a minute about some common defenses that owners raise. And Bruce, I'll turn it over to you for a few minutes to talk about these common defenses that we see.
Well, so the ones you have listed here, the first one is, often owners will claim that there isn't authority to levy the assessment. But that's usually pretty clear. It's set forth in the governing documents, and if it's not there, obviously you shouldn't be assessing. So rarely do I see that successful. I've seen owners try to argue that the governing documents are some way invalid. They may not, that there may be some. I've seen owners try a statute of frauds argument to say that it wasn't signed by him or her, and so the association can't enforce it. That doesn't fly. The covenants are enforceable. It's pretty straightforward. Offset's another common one. This is one where owners will say the association hasn't been meeting its duties, so perhaps you're not the board's not maintaining the common property correctly or not providing the services that it's supposed to. So the owners say, I'm not gonna pay my full amount until the board does what it's supposed to do. That also isn't going to fly. In Oregon, at least, there's a specific statute that says you can't do that. Discrimination, owners will argue that they're somehow being treated unfairly or differently. Obviously, I rarely see that actually be the case. No notice when it comes to collections of assessments. Kevin, are you referring to, owners saying that, well, I didn't know that I had to pay this amount?
Yeah, or I never got anything in the mail saying I had to make a payment by January 1st.
Yeah, that's interesting. Have you ever seen that successful?
No, but
if the association really wasn't sending out any notice of its assessment and just adding it on to their ledger, I think the association might actually run into some trouble in that regard. But generally speaking, some sort of notice is going out. There's a requirement to go through the budget process and to send the budget out, and that budget will set forth the amount that owners are supposed to pay. So if you're not doing that, I suppose you could run into trouble, but I've never actually seen that.
Yeah. Bruce, let me ask you something else. Hang on. Let me think of how to phrase this here. In terms of, actually, let me come back to that. There was one last slide, and we're going to have a lot of time for Q&A. Talk for just a sec about the FDCPA. I touched on it a minute ago, but are associations, are managers subject to it?
Generally speaking, it's if a certain percentage of your practice or common aspect of your practice is the collection of debts. So for associations, that they are not subject to the act. Us as attorneys, we are, because we do it often enough that the act applies to us. I don't believe it applies to management companies. But I'm not sure of that.
Yeah, there's been some federal cases that I've seen that have inferred that it's possible, especially if they do a lot of it routinely as part of their business. One more for you, Bruce.
Mhm.
Association levies a special assessment to do repairs, or because their maintenance or their reserves are underfunded. Are special assessments treated just like other assessments? And I know you've talked about this, but talk about special assessments for a moment.
They're all assessments. I mean, it's assessments are assessments. Any charge levied against the law is an assessment. They're all treated exactly the same.
Any charge? What if the documents say that a special assessment requires a vote of 2/3 of the owners and the board did not get that? Is that still an assessment you could collect if they didn't follow the procedures to levy it?
No, that's not an assessment. That's not a valid charge. If you haven't followed the documents, you haven't properly levied the assessment.
Touche. Okay, good point. Wow, I got through a lot of this quick, mainly because there weren't a lot of questions, but we've got 15 minutes Q&A about anything related to HOAs, not just collections. What do you got? Otherwise, I'll just start talking about random things. First and foremost, have you seen this John Oliver news thing that went viral where he really is sort of critical of HOAs? It hurt my feelings, even though he's a funny comedian. Have you seen it, Bruce?
No, what did he say?
He just goes on a rant about homeowners associations. And a lot of my friends and even board members have sent me links to it. I've gotten links to it from like 3 or 4 different people.
Was it recent?
Very recent. In fact, Google it and I'll let you share the screen. Maybe we'll watch it if there's no questions. But questions, comments, thoughts? Any of you facing issues with collecting assessments? Hopefully not. A lot of it sort
I
of.
have a question.
Yes, please, Rhonda.
If you get a offer for a amount due that's under, you said you make a recommendation. How do you make that recommendation? Based on what?
Yeah, a lot of stuff. So depending on the matter, we may have a lot of information, whether or not they have a steady income. Occasionally, we will make a determination of whether or not there's bank accounts and funds there. Likelihood of defaulting on a payment. So it's a lot of it's based. I'd say a big part of it is based on the due diligence that we do when a collection file is turned over to us. And another part of it is just based on our experience. So our recommendations are completely specific to the facts of the case. But yeah, it's based on our experience, based on the information that we have at that point, whether there's income, whether or not there's a bankruptcy that's been filed. Sometimes there's a notice of foreclosure. So a lot of those things go into our analysis when we make a recommendation to the board. Great question.
That makes sense. I
Great
was
question.
wondering, just because there are a lot of folks who would say, I pay my share. What are you going to do about this idiot that's not paying their share?
No, and Rhonda, you hit the nail on the head there with the importance of assessments. The way that I look at it is fundamental fairness. Because if your neighbor's not paying their assessments, guess who's making up that shortfall?
Right.
You are.
Yeah.
And so I that's the way I view it.
But Kevin, don't you usually recommend some sort of leniency towards people named Kevin?
Yes, in fact, where's Kevin Dorowski? Are you still here? I saw, yeah, and I was just telling Bruce earlier today that I've never met a Kevin that I didn't really like. Are you here, Dorowski? Good to see.
I'm here.
How are you, sir?
I'm doing well.
Good, good. Let me ask this. Any tips or tricks? So Kevin was a manager of community associations in Oregon for many years. Any tips or tricks on assessments collection?
I think something that you mentioned earlier happens sometimes is that people will, once you contact them, will say that, oh, I changed banks and I forgot to switch over my account for so my assessment can be automatically withdrawn. And sometimes those resolve really quickly. People may not respond to a letter or a note or an email, but they will do a phone call.
Yeah, great point.
We got a couple questions in the chat, Kevin.
Oh yeah, fire away. Go ahead, Bruce.
So Roberta's asking, is it okay to phone a delinquent owner and talk to them?
If it's prior to turning it over to us or any other collection agency, I say fine. The more contact, the better, because as Kevin Dorosky, my second favorite, my first favorite is of course myself. My second favorite, Kevin Dorosky recommended. Yeah, sometimes it's an innocent mistake and a phone call can resolve it before anyone spends money or time or effort. So I'd say yes, nothing wrong with that. However, if it's turned over to an attorney or a collection agency, generally speaking, you're going to want to avoid any conversations with the delinquent owner regarding that matter.
Okay, next question is, if an owner keeps getting fined for something, can the HOA send the property into collections or lien the property?
Yes and yes. And the follow-up was what would trigger it? Again, that completely depends on the association's collection policy.
That would
go ahead.
In terms of what would trigger sending it to collections, the lien is automatic.
True. Oh, yes. Yes. Thank you for that clarification. That is true. But yeah, some associations, the trigger is, $500 once the balance is $500 or more. Others, it's by time once it's 90 days delinquent. So it completely is up to the association in terms of how they structure that policy. Great questions.
Kevin, how often have you been delinquent on your $70 a year assessment?
Yeah, actually, many years ago, I was delinquent, but I didn't know it. My mail got stolen for like 3 days in a row, and I was like, "That's weird." No, I promise, because they even used my credit card at like a guitar store in Eugene, REI in Seattle, but a whole bunch of mail, including my notice of assessment that year. But Carol, who is still the board treasurer, came over and said, "Kevin, what's up?" And I said, "What do you mean, what's up?" And then I wrote a check. Now, also, I was the board chair of my association for 3 years. And then there was a coup. And I was thrown out. No, I wasn't. I did my civic duty and then I resigned. But it was fun. It was a lot of folks called it a mini dictatorship when I was the chair of my HOA. And I don't know if that's a compliment. I'm thinking it's not. Bruce, Tom asked, when is it said that fines must be Bruce can talk to you for at least an hour on the legal concept of reasonableness.
Yeah, when it comes to fines, reasonable, I think, is just that, that the board has put some thought into it. Frankly, I mean, ultimately, the fine has to be set at an amount that will actually deter the behavior. So you have to take into account all of the circumstances in your particular community. What's the general, ability to pay fines? What's the severity of the infraction? What amount of money is actually going to achieve the purpose of the fine, which is compliance with the governing document. So I've seen some associations that levy fines that would seem initially kind of extremely large, so for instance, I've seen associations that would levy a $10,000 fine to remove a tree if you remove a tree without permission. But sometimes in that circumstance, the homes are $5 million homes, and if you remove that particular tree, it'll open up a view that might be $100,000 view. And so the only way to get compliance is to set that fine at amount that will actually deter the behavior, or else the owner's just going to say, I'll remove the tree and pay the fine.
And we've seen that happen. And then that's usually a signal that the fine isn't enough.
Yeah. So reasonable, I think, just means considered under all the circumstances.
I have a question.
Here's a good question, Kevin. I get this a lot. When an owner is delinquent, can they serve on the board?
Now, not very many. I've seen some documents, very rare, that prohibit service on the board if you're delinquent. But generally, you don't see that. And my position is yes. I think it's crazy. But unless your documents have something specific that says they can't serve on the board or being delinquent disqualifies them. Now, Bruce, what if they do serve on the board, they're delinquent, can they vote on whether or not to pursue collections against themselves?
Is that a conflict of interest? I think they can vote. I don't, the. conflict of
Yeah, Bruce,
statute doesn't-
actually, Bruce is right, but I don't tell people that because there's the legal definition of a conflict and there's what the perception of a conflict is. And those are two very, very different things. Let's see, there was a question from
So from
Cliff?
Rebecca said, is the board allowed to increase fine if the original amount doesn't stop the behavior? And the answer there is no. Fines have to be based on a schedule of fines that was previously adopted and distributed to all owners. So now you can revise the schedule of fines and then distribute that out to all owners and then levy fines in accordance with the revised schedule. But you can't just change fine amounts on the fly just because the owner's not complying. It has to be based on the schedule. So let's see. And then our community management company said that the president could not contact owners who were delinquent. They said all communication had to go to the management company and we're ready to have it go to collections. So that it may be an aspect of the management agreement with the management company and the associations. I don't know that there's a rule of law about that. I think that's an issue of your agreement with your manager.
Hey, Bruce, Cliff, I think I've cut you off or Bruce has cut you off. My apologies. The floor is yours, Cliff.
Oh, I just sent you a text message. At the beginning of the meeting, you made mention of a schedule of fines being required before you can proceed with these issues. If that's something that an HOA does not have, I mean, I'm guessing it's prudent to establish one.
Absolutely. And let me share my screen again. I'll just show you a very broad example of a schedule of fines here. And again, the schedule of fines is going to be different for each community. So this one, nuisances, unsightly conditions, $25 a day, unlawful activities, campers, boats. Now, this schedule of fines is going to be different in a condominium than in a planned community. The amounts are going to be different depending on your community. But the concept is, and Bruce, tell me if you agree, the concept is that if owners do something in violation, they should have some general idea of the consequences.
Absolutely. Yeah.
And that's the whole purpose of it.
So Bruce, I'm also guessing that each one of these elements I'm looking at have had due consideration for what is reasonable.
They must, yeah, the fines must be reasonable. And so now, ultimately who determines whether something is or is not reasonable? Well, I guess it's a court, it has the final say. But yeah, and generally speaking, everything that a director does has to be reasonable. And so when you're deciding that amount to put in your schedule of fines, the board needs to act reasonably. But that schedule does have to be adopted and then distributed to all owners before you can levy fines in accordance with it. And yes, you're absolutely right. It's a critical resolution that every association should have in place.
Okay, thank you.
Now, we've got 2 minutes left. I'm just going to share my screen again to give you a preview for next month, which is one of my favorite topics, avoiding liability. We'll talk about fiduciary duties. We'll talk about common claims, tools and techniques to avoid liability, and then spend a little bit of time on insurance coverage. And frankly, insurance is one of the most important topics, in my opinion, for every board member to be aware of, because that is your biggest tool when it comes to risk management. Other questions, comments? I had fun tonight. I know this isn't the most glamorous topic, as I've said, it's important. But great questions, comments. Good to see a lot of my friends that I see regularly. Joni, Ken, a bunch of you actually. Bruce,
It's great information. Thank you.
good. That was, Hi,
Where can
yes,
someone get a
Colleen.
sample copy of the schedule of fines?
You know what I'll do? And if it's not on our website, I'll post it probably in the morning. I'll post just a sample schedule of fines to give you a rough idea. I'll have a big disclaimer that says this is for, reference only and don't rely on this, but it'll be similar. I'll do a couple of, ballpark ones like I just showed you, one for a condo, one for a non-condo to give you a basic idea.
Great, thank you.
Yeah,
And
Michael,
Cliff,
did you have your hand? Oh,
a schedule can be as complicated or as simple as the board decides to make it. So the one that Kevin showed is very specific. There's different fines for different infractions. Other schedules might be very simple, that any CC&R violation, whatever, gets $100 a month fine. It can be as simple as that. So there's no requirement. It just has to be, as Kevin said, I think owners have a right to know what the consequences are of violating the CC&Rs.
and
Okay,
then Kathy asked, if you modify the schedule, do you have to give notice before implement? Yes, and that, what's reasonable, 30 days, I would say, is reasonable notice before you start implementing the new amended or modified fine amount. And then Michael, did you have your hand up a minute ago? I thought I saw it out of the corner of my eye.
Oh, that was a clap, but actually,
Oh,
yes.
hey,
Actually, I think in the past we might have had conflicts of proving violations such as noise and smoke. That's been, to say who in our community, what we like to do is we say, hey, email it to the community manager. So we're managed, obviously.
yeah,
Email it to the community manager. Because being a board member and living on site, you also want to have your personal
yeah,
space as well. Like, don't
yeah,
come to me with that.
yeah. Do people
but
observe that and leave you alone, or do they text your personal?
No, I think my question more is gearing towards proof. Like, how do you prove somebody is being too noisy or
yeah,
being, those little nuisances? I mean, it's
yeah.
obvious if somebody
That's a
gets
great
horse,
question,
it's obvious,
and frankly, we
but
could probably do a class on that.
Don't we
been
have a
involved-
class on that, Kevin, on enforcement and
We
rules?
Actually, I think we do coming up in the fall. But what I was going to say, Michael, I've been involved in situations where we've had acoustic experts come out with a decibel meter. Had folks come out, depending on on what the violation is, maybe experts are necessary. But yeah, what you're asking is sort of from an evidentiary standpoint. Photographs of violations are very important and very, very helpful. Video footage of violations. But one of the other reasons that the law requires this hearing before you levy the fine is that's the owner's opportunity to say, hey, no, so-and-so is too sensitive and it's really not a violation. It gives the owner who might get fined or is accused of a violation to plead their case. That's the whole point. But yeah, depending on the violation, Michael, there could be a variety of ways in terms of proving it or validating it. And I know that's a very lawyerly answer.
You've got another question in the chat, Kevin, or two.
I see in the schedule displaying a sign without a political signs. Whoo, boy. That's a hot one, and we're already a minute over time, but I hate to tell you all this. There are no First Amendment rights in homeowners associations. But maybe we'll do, this is one of my favorite topics, free speech, signage, political rights, that sort of thing.
Isn't that on June 21st? Aren't we doing rules and regulations?
No, we are. Actually, we'll
include something in there.
Yeah,
about
Francie, we will address that
political speech.
in our June one. That's a great question and one that we could spend a lot of time on. Well, folks, thank you very much for spending an hour with us on a Wednesday evening. I hope it was educational. We have a lot of fun doing this, and we look forward to seeing you next month for avoiding liability. Take care, everybody.
Thank you.
Good evening, everyone.
bye.